Let's start our second session of our course with Professor Lars Vinx, Hans Kelsen, and Carl Schmitt. And today we will have the comments by Professor João Costa Neto, who is from the University of Brasilia, but now he is visiting Professor Vinx City to know better the atmosphere of his thought. He is now in Hamburg, and he will make some comments after Professor Vinx's lecture. And as you know, we had in the first semester a brilliant class on Carl Schmitt by Rodrigo, and now we will have the second only class you will have about Carl Schmitt in our law school, because it's not a so studied author. We have a few books about Carl Schmitt. One is this one by our head of the Department of Jurisprudence and Philosophy of Law, Professor Ronaldo Macedo, who wrote about Schmitt in the 90s. And this book has also a translation of two important texts by Schmitt. One of these texts was recommended for today on the 3 types of juristic thought. So it's a great opportunity to discuss an author who is very politically influential, but it's not so present in the law school curriculum because he is not a positivist, he is neither a natural law theorist, he's not a sociologist, he's not a realist. It's difficult to place Schmitt in one category alongside other legal authors. So this points out to the originality of his thought. And we also recommend, I put in the drive, that book that Professor Vinx organized with Schmitt's early legal theoretical writings. So let's start. Thank you, Lars, and the floor is yours.
Yes, thank you very much. This is the second of the lectures, the 5 lectures on constitutional guardianship. And so what I want to do in this lecture is to explain why Schmitt is driven to the view that constitutional guardianship should not be exercised by a constitutional court, but rather by the president of the Weimar Republic, or more generally, the person who is the head of the executive in a constitutional system. And so to try to explain that preference that Schmitt has for executive guardianship, it's helpful to look at some background both in his legal theory and in his constitutional theory. So I'm going to try to give an overview of some key themes in Schmitt's legal and constitutional theory that are relevant for understanding his preference for presidential or executive guardianship. So accordingly, here we are going to have 3 parts in the lecture. I'm going to begin by talking about Schmitt's legal theory and his theory of adjudication in particular. Then we're going to address some ideas from Schmitt's constitutional theory. And finally, I'm going to talk about what these imply for his conception of constitutional guardianship. So the first text of Schmitt's that I want to discuss is a book that Schmitt published very early in his career in 1912, so just 2 years before the First World War broke out. And this is a legal theoretical work in which Schmitt attacks a view of how adjudication works that people usually refer to as statutory positivism, or in German, Gesetzespositivismus. So here I have a brief extract from a text that's not from Schmitt, but from Hermann Kantorowicz, who was a legal theorist as well in the early 20th century in Germany, who was, like Schmitt, opposed to statutory positivism. And here in this extract that you see on the slide, Kantorowicz gives a kind of satirical characterization of this legal theory, statutory positivism. So he says that the prevalent ideal conception of how a legal system should operate is the following. So there's a higher officer of state with academic training. So I guess that's a judge, or perhaps an administrative official. This person sits in a cubicle, armed only with a thought machine, but one of the very finest sort. So of course the thought machine is the person's brain, right? So it's not a real machine. The room's only furniture consists in a green table on which we find the statute book lying in front of the official. And now someone hands him some random case, perhaps a real legal case or an invented case, and in accordance with his duty, this official is then able to prove the decision that is predetermined by the legislator with absolute exactitude, with the help of purely logical operations, and by the use of a secret technique which is comprehensible to him alone. Okay, so of course you can see that Kantorovich does not think that this is a descriptively accurate picture of what happens when a judge decides a case, but it gives an outline of the view, statutory positivism, that both he and Schmitt want to assail. So some of the key tenets or the key ideas of statutory positivism are the following. So as you can see from a Kantorovich quote, the view takes it that all law is statutory law made by the legislature. There's also a claim that there is a right answer to any legal dispute that might arise between two parties that is provided by statutory law. And so from this, the conclusion is drawn that an adjudicator, a judge, for instance, will always be in a position, will always be able to identify the right, the legally correct answer to any legal dispute. And furthermore, the idea is that the adjudicator can do that without relying on their own moral or evaluative judgment. So they can do it simply by interpreting the statute according to the rules of interpretive technique and then executing the legislator's will in taking a judgment. So the fourth claim then is adjudication is just to apply a decision that's already been taken by a legislator to a particular case. And the view is furthermore that a judicial decision is correct, it's sound, if what it does is just to faithfully apply or to faithfully implement the decision that the legislator has already taken about how the case ought to be handled in making a law. So this is the view that Schmitt sets out to attack or to undermine in this early work, Statute and Judgment. So the main claim that Schmitt makes against statutory positivism is, I'm assuming, quite familiar to you. So it is that statutory positivism misdescribes what really happens in adjudicative practice, what really happens when judges decide cases. So there are a number of well-known facts about the process of adjudication that undermine the picture offered by statutory positivists. So the first of these is that the application of a general legal rule will often have to grapple with problems of indeterminacy. So I imagine that most of you will have taken a jurisprudence course, so you're familiar with the standard example that's used to illustrate this problem that Hart puts forward in his concept of law, where Hart imagines that there's a sign at the entrance of a park that says that no vehicles are allowed in the park. Right? And then someone comes along and wants to ride their bicycle into the park or wants to traverse the park on their skateboard. And there's a question whether in doing so they violate the rule that you're not supposed to take vehicles into the park. Is a skateboard a vehicle? Well, it's hard to say. So it seems that ordinary language does not define or determine the term vehicle specifically enough, precisely enough, for us to know whether a skateboard is a vehicle. So someone who wants to apply the rule that no vehicles are allowed in the park, they're just going to have to take a decision on this, right? Whether a skateboard is to be regarded as a vehicle or not. And such problems of indeterminacy afflict many legal rules. So most legal rules have terms in them that have a penumbra of indeterminacy, as Hart put it. And of course, whenever such problems of indeterminacy arise, the picture painted by statutory positivism breaks down. Now, to make matters worse, of course, if such problems of indeterminacy arise, the legal rule itself that is to be applied, it can't tell the adjudicator how it is to be applied. So if it is to be applied in a way that's predictable or calculable, then it must be applied in line with conventions, with practices, with customs, perhaps with a sense, in line with a sense of appropriateness that is shared by those who are participants in legal practice, by judges and legal officials. It may even be the case, Schmitt observes, that courts take decisions against the law, against the statutory rule, not against the law, but against the statutory rule. But these decisions are accepted as correct because they reflect established judicial practice. So if all these observations are true, then it makes no sense that to say that a judge who applies a legal rule does nothing more than to faithfully implement the will of the legislator. So rather what we should say is that the will of the legislator is created in the process of interpretation, which involves, again, understandings, customs, habits, conventions that arise within legal practice among legal officials that are not predetermined by a legislator. Now, if these observations are correct, because then one conclusion you might want to draw from them is to say that, well, and this would be the legal realist view, to say that, well, judges often have discretion when they decide particular cases. Statutory law doesn't pick out a unique solution to a legal problem. There are a number of different options that judges can choose between. And if they do that, then, well, judges legislate, okay? Though perhaps only within certain limits or boundaries set by the core of determinacy of statutory law. Now, Schmitt does not want to draw this conclusion. Okay? So though he thinks that statutory law does not uniquely determine particular outcomes to legal cases, he wants to say that judges are still bound strictly to law which programs their decisions. It's just that this law isn't exclusively composed of statutory rules. So Schmitt turns to legal practice and he says, in order to understand how it is possible for legal decisions to be determinate, to be calculable, we have to look at how judges actually achieve determinacy and calculability in their decision taking. And so the first claim that he makes is that judges are all committed, or legal officials are all committed to making their decision taking calculable or determinate. But of course, as we have seen, they cannot do so simply by slavishly, automatically, robotically applying statutory rules. So to achieve calculability, predictability, legal practice has developed conventions, customs, perhaps a sense of appropriateness shared among legal officials. And Schmitt believes that these factors are capable of making judicial decisions predictable. Okay? Now, related to this analysis of how legal practice works, Schmitt puts forward a criterion of correctness for judicial decision. Right? So we've seen already that he rejects the criterion that the statutory positivists would use, which is to say that a judicial decision is correct if it faithfully implements the statutory rule. So Schmitt thinks a better criterion of correctness is to say that a judicial decision, a decision taken by a judge in a particular case, it's correct if and only if another judge, another legal official in the same legal system with the same legal education, the same legal experience, if another judge would have taken the same decision. Okay? So put yourself into the shoes of a judge who is to decide a case that perhaps you find difficult. Okay? You ask yourself, how should I decide the case? And so what Schmitt tells us is that you should ask yourself, well, how would my peers, how would other judges, other legal officials that work in the same legal system as I do, how would they decide this case? And if you can answer this question, so if you can figure out how another typical judge would decide this case, then what this criterion of correctness tells you is you should decide the case in the same way, in the way that another judge would decide. Okay? And so the idea is that if all judges follow this rule, then everyone will know what decisions are likely to be taken, even when a difficult case arises. Okay? Good. So there are many questions that could be asked about this, and I'm just going to focus on one of them, I guess, which is especially relevant. But before I go there, I just want to point out that Schmitt, like the statutory positivist, is a kind of formalist. So he believes that there is no legal indeterminacy, that all legal disputes can be given a determinate answer. Okay, so he denies the claim that all law is statutory law. Right? So there are also practice internal conventions and customs that are legally relevant. But once these are in the picture, there's still a right answer, according to Schmitt, to any legal dispute, at least given suitable conditions, about which we will talk on the next slide. So the claim is that an adjudicator can always identify a correct answer without relying on their own moral or political judgment. It's just that they can't do so by appeal to statutory law alone. Right? So their own understanding of legal practice will have to play a role as well. But it follows, of course, that adjudication is not the execution of the will of the legislator. But still, judges are called upon to decide in the way that another judge would, so they are still bound to the law. They're not allowed to exercise discretion or to decide difficult cases in line with their own view about what solution to a case would be morally or politically best. Good. Now, I said here already that the claim that Schmitt puts forward is that there's a right answer to any legal dispute, but only under suitable conditions. So recall that Schmitt claims that a judicial decision is correct if another judge would have taken the same decision. So to find out as a judge what decision I should take, I must be able to predict how another judge would decide the case that I'm faced with. And the question that obviously arises, what are the conditions under which it is possible for a judge to predict how another judge would decide a case? So of course, judges will often disagree, as you're all aware, about how cases ought to be decided. Okay? But if judges disagree about how cases ought to be decided, then no individual judge will be in a position to predict how another judge would decide the case that they are faced with, right? So legal decision-taking or adjudication is possible only if such disagreement doesn't arise. And Schmitt seems to think that disagreement won't arise if two conditions are fulfilled. So one of these is a condition of homogeneity, and the other is a condition of normality. Right? So the condition of homogeneity claims that members of the judiciary must share a common education, a common outlook. They must support the same customs and conventions, and perhaps they must have the same Rechtsgefühl is the German term. So this means the sentiment for what's right or for what is law, a sense of legal appropriateness. So legal officials must share these characteristics. There must be a homogeneous group in order for individuals as members of this group to predict how another would decide. And also a condition of normality needs to be satisfied. So we must be in a situation where courts are not confronted with unexpected problems or unexpected cases for which judicial practice hasn't yet established, recognized, agreed upon solutions. And so the claim is that when these two conditions are satisfied, when they are fulfilled, then judges can work with Schmitt's criterion of correctness. They can predict how another judge would decide. And if they then take that decision, they are deciding correctly. But if these two conditions are not satisfied, then it won't be possible for judges to predict how other judges would decide. And that means that they can't take correct decisions, because in a sense there is no law. So when there is disagreement that makes it impossible for judges to predict how other judges would decide, then the possibility of adjudication ends. The decision turns political or quasi-legislative, and such decisions, Schmitt thinks, cannot be taken by courts. They must be taken by institutions or by persons who have the legitimacy to legislate. Good. Now, Statute and Judgment, as I said earlier, it was a very early work of Schmitt. So it was published in 1912 in the last years of the Wilhelmine Empire in Germany, which was generally a quite quiet period, I suppose. And Schmitt may have thought that when he wrote Statute and Judgment, that these two conditions of normality and homogeneity, they were fulfilled. And for that reason, he did reflect on a further element of legal order that he brings into play in his work in the 1920s and 1930s. And so I want to introduce you to that further aspect of his thought by talking a little bit about a later text, The Three Types of Juristic Thought, in 1934. And the theory that's developed in this text can be seen as a response to the question, well, what happens? What should we do if these two conditions here of homogeneity and of normality are no longer satisfied? So in this text, The Three Types of Juristic Thought, as the title already tells you, Schmitt distinguishes three types of juristic thought. And I think the reason why he does that is not so much because he wants to pick one of these as the true type of juristic thought and relegate the others to the dustbin. So the reason why he's interested in pointing out that there are these three types of juristic thought is because he thinks that there are also three different structural elements of a legal order. And each of these three types of juristic thought focuses on one of these elements at the expense of others. But to get a full picture of legal order, we have to take all three elements into account. So that is the message, I guess, of this book as a piece of legal theory. So here are the three types of juristic thought. So on the one hand, Schmitt says there is normativism. Normativism is another name, if you want to put it that way, for statutory positivism. So it's the claim that the law consists of general rules and that the operation of a legal system is to apply general rules to particular cases in accordance with the intentions of legislature. But we've seen already that Schmitt thinks that this view is problematic, or that it's at best incomplete. So it overlooks or it abstracts from the fact that for law to exist, for legal determinacy to obtain, and normality that must also be satisfied. Good. Now, suppose that these conditions of normality and homogeneity are not satisfied. Judges can't predict how other judges would decide. How is a legal order to respond to that type of crisis? So that is where the idea of decisionism comes in. And so I think some of you may have had some acquaintance with a text of Schmitt's in which decisionism comes to the fore, which is called political theology. In political theology, Schmitt begins his book by saying that the sovereign is he who decides on the state of exception. Okay, so the claim is that in any legal order, there must be a sovereign authority. And the sovereign authority is not defined by possessing a supreme legislative power for Schmitt. The sovereign is defined, or sovereignty is the power to switch off the legal system as a system of norms, to suspend it altogether in response to the perception that the conditions of homogeneity and normality in a situation of crisis no longer obtain. And what the sovereign is supposed to do, having switched off the law, having suspended legal rules as normative rules, is to recreate a situation of normality and of homogeneity that will once again make legal rules applicable in a predictable way. Okay? And finally, we have concrete order thought. The concrete order thought is Schmitt's version of legal institutionalism, of French and Italian legal institutionalism. And this view claims that the law, as a system of rules, it should take its content from the social conditions of homogeneity and normality. So the concrete forms of life that have grown in a society and which provide the underground or the underpinning for normative legal rules to make sense, to be applicable with determinacy and predictability. So we arrive then at a picture of legal order that says that in any legal order you have three elements. So you have the capability for someone to take a sovereign decision, a decision on the exception that suspends the law as a system of rules altogether in order to deal with a situation of grave crisis. Then, of course, you have legal rules, as the normativist claims. So the laws that are enacted by a legislator and that perhaps can be applied with reasonable predictability given that the situation of normality obtains. And then, of course, you have the situation of normality itself, which Schmitt describes as concrete order. Okay? He was very fond of coining terms, and so you will find in his work that many ideas are successively introduced with ever-changing terminology. But I think concrete order just means for him a condition of normality and homogeneity. Okay, so really what you have here is an established social order. You have legal rules that work well because they correspond to that established that's established social order. And then you have a sovereign who can intervene in case the alignment between legal rules and the underlying concrete order is destabilized in some way. Now, why am I going into all this detail about Schmitt's conception of legal order? It's because I want to argue, moving over to Schmitt's constitutional theory, that his picture of constitutional order is just a specification of his picture of legal order in general. So I should say that Schmitt's constitutional theory predates the publication of the three types of juristic thought. But I think what the three types of juristic thought does is just to explicate a conception of legal order that is already implicit in Schmitt's constitutional theory. Good. So we are turning to Schmitt's book Verfassungslehre, or constitutional theory, in which he tells us what a constitution is. And his answer to that question is quite complex, surprisingly complex. Okay? So what is a constitution? So you would think that a constitution is a written document that contains a number of articles that lay down a set of legal rules that play a certain preeminent role in a country's legal system. So that is what a constitution is, right? A set of legal rules that have a higher degree of validity or bindingness than ordinary statutory rules. Now, Schmitt himself recognizes, of course, that you can look at the Constitution in this way. So there is a legal constitution, but he also thinks that this is not the only constitution there is. There is also something he calls a positive constitution. And so the positive constitution is yet another piece of terminology that homes in on something we've already encountered. The positive constitution is just the basic political order and social order that underpins the constitution and that is presupposed by the constitutional norms that are contained in the written constitution. So here you see that there's an equivalent both to the element of rules and to the element of concrete order. There's a third element in the Constitution, that is the constituent power, which takes the place of the sovereign in the general model. So the constituent power is the power that is capable to create a constitution, to put in place a written constitution, but also to decide on the type of social order, concrete order, that is to correspond to the rules of the written constitution and to make them meaningful and applicable. Okay? So perhaps it's helpful to spell this out a little bit more by reference to an example. So Schmitt, of course, was writing about the Weimar Constitution, the Constitution of Weimar Germany. And the Constitution of Weimar Germany was the result of a democratic revolution that in 1918 and 1919 had swept away the monarchic system that existed beforehand. So there is a claim that the people, acting as constituent power, led perhaps by certain politicians who could claim to be representatives of the will of the people swept away the old constitution, and in doing that took a fundamental decision about what kind of state ought to be created. And so Schmitt claims, and I guess that's a plausible claim as far as these things go, that in the course of the revolution, the people, the constituent power, committed to a democratic republic that was supposed to be federal, that was supposed to have a parliamentary system of government, that was supposed to bring about a separation, but not a total separation of church and state, and that was to preserve private property and the capitalist economy. So Schmitt says those were the fundamental decisions taken by the people acting as constituent power when they removed the prior regime. And these fundamental decisions were then implemented by an elected National Assembly in a written constitution. Okay? The idea is that the written constitution must be seen in the context of this revolutionary decision. So the positive constitution that contains the basic principles of political order precedes it. Okay? And the claim is that the rules of the written constitution must be interpreted in light of the prior decision on the part of the people as constituent power for a fundamental conception of political order, the positive constitution. Okay? So one implication of this, for instance, is that Schmitt thought that the parliament that had been created by the written constitution did not have the power, not even when using the amendment rule provided by the constitution, to take an amendment to the constitution that violated the content of the positive constitution. So for instance, it would have been unjustifiable, according to Schmitt, for Parliament acting with a 2/3 majority under the amendment rule to introduce a socialist economy into Germany, even though the written constitution did not contain any limitations on procedurally valid constitutional amendment. Good. Now, the constituent power is supposed to create the positive constitution, which then guides the creation of a legal constitution. So the constituent power, the people acting in that capacity, must somehow pre-exist the constitution. It must be there before a constitution is made. And so here you have an extract from Schmitt's constitutional theory, in which he emphasizes this idea very strongly. So he says the constitution in the positive sense comes into existence through an act of the constituent power. So this may be a revolution, right? An act of constitution giving, he says, does not contain any particular norm. So the first thing that happens is that the old regime is swept away and the people opt for certain fundamental principles of political order. So the act of constitution giving therefore determines the whole of political unity with respect to its particular form of existence in a single decision. And he says this act constitutes the form and kind of a political unity whose existence is presupposed in this act of constitution making. So to put this in simpler terms, the idea is that the people must be there before a constitution is made. Right? So it's not the case, he goes on to say, that the political unity comes into existence only because a constitution was given. So think of the theory of social contract as you find it in authors like Hobbes or Locke, right? So there's the idea that individual persons run around in a state of nature, there is no public authority, and then they decide to band together to make a contract with each other, to give themselves a government. And it's when they do that that they become one unity. Okay? So they are a unity only because there is a government that represents them all. But here the claim is that, well, a political unity can exist before a constitution has been made. And there is no social contract when a constitution is made. What happens is that this people that already exists decides, oh, this is to be my constitution, or our constitution. So the constitution, in the positive sense, merely contains the conscious determination of the particular overall form for which the political unity decides. And then he says this form can change. So once a constitution has been made by the people can decide perhaps at a later point to make a new constitution, right? It is possible for fundamentally new forms to be introduced without the state or the political unity of the people ceasing to exist. But in all cases, he says, this act of constitution giving, it requires a subject capable of action, a group of people who can decide to make a constitution. Good. And of course, the question that arises from this view, quite obviously, is, well, how is it possible for there to be a people as a collective agent capable of making a constitution if there isn't any constitutional law, no voting rules, right, or no procedures for taking collective decisions? How can people be integrated into a group before there is a constitution, a political group? Good. So let us try to take a brief look at the conception of political unity that Schmitt is working with. This idea is drawn out in most detail in a little book that's very famous, which is called The Concept of the Political. And so what this book tries to do, The Concept of the Political, is to explain how a group that is a political unity differs from other types of groups, right? So I suppose there's a group of the people who are friends of Corinthians, or there's a group of people who have blonde hair, right? Or there's a group of people who like to drink beer. There are trade unions. There are universities and all the students and teachers working in it and for it. Okay, these are all groups or associations, churches. So these abound in social life, but most of them are not political. And so what Schmitt is interested in is what distinguishes a political unity or a political association or a state from all these other types of groups. Now, the first step here to answer this is to say that Schmitt understands a political unity as a group of people who identify with each other, who recognize each other as belonging to the same group, and whose identification with each other is political. Now, this is not very helpful, so we need to know what it means for people to identify politically. So I guess one thing it means is that the people who belong to the group must recognize that they have something in common. Okay, so I guess to use the example that Schmitt perhaps was thinking of, the people who make up the political community, that is the German people, they recognize each other as German, right, on the basis of certain cultural or linguistic characteristics. And they are mutually aware of the fact that they share in the features that make you a member of the German nation as an ethnicity. Okay? So that's part of political identification. But of course, this identification also applies to non-political groups. To say all Catholics might identify with each other knowing that they believe in a certain version of Christianity and be aware of that fact. But we do not think of the Catholic Church as a political community. So what makes the German people, Schmitt thinks, political is the fact that the identification that people have with each other gives rise to what he calls a friend-enemy distinction. So a political group is a group whose members consider each other as friends and who consider the people who don't belong to the group, who stand outside, as enemies. Okay? So what is an enemy? An enemy is someone who is so different or so alien to the group that perhaps they might have to be fought by the use of organized violence. exercised by the group. So I identify politically with the group if I am willing, say, to fight and perhaps to die for the group, for the independence, the autonomy, the self-determination of the group against external enemies. Okay? So the German government and other governments in Europe, of course, they had the ability, when the First World War started, to just send millions of people to die in the battlefield. Okay? And people followed that call. So they enlisted and they took the train to the front and they jumped out of the trench and ran towards the machine gun, and many of them died. Okay? So that the state has the power to make people do that, perhaps even willingly, that makes it a political community. That the Catholic Church does not have the power, we assume, to do anything of the sort, means that it's not a political community. Okay? So if it is the case that people identify in this political way with each other, of course, they can do so even if there isn't as yet a political system that is their state or their constitution, right? So I suppose a people that is subject to colonial rule might be a political unity once people identify politically with each other and then take arms to fight against the colonial oppressor. Okay? In that case, there would be a political unity, even though they haven't yet managed to give themselves their own constitution. Okay? So I hope this gives you a sense of how Schmitt can say, or why he can say, that political unity can exist before a constitution has been made. So a constitution is, a positive constitution is the form of political order that a political community gives itself, and that is then implemented in a legal constitution, a written constitution that contains certain legal provision. Yeah, so let me say a few more words about the people as constituent power. So we said already that when the people give themselves a constitution, this is a unilateral collective decision. So it's not a treaty or a contract. So the people decide to create a democratic republic. But this decision remains valid or binding only for as long as the people don't decide otherwise. So Schmitt thinks that the constituent power isn't alienated or used up once a constitution is made. So the people as a nation, as a political unity, continues to exist alongside its constitution, and it could, in principle, in the future, decide to give itself a new constitution. The people are unhappy with the constitution that has been created in the past. And Schmitt thinks that because the people stands apart from the legal constitution in this way, the legal constitution cannot define in advance how constituent power can be validly exercised. Okay? So any presumption on the part of the constitution to do that would bind or would restrict or would bring about the alienation of the constituent power of the people. But for the people to accept this alienation would be to give up their independence, their autonomy as a political unity, which is something Schmitt thinks they shouldn't and won't do. Now, perhaps one further thing to point out here is that when a constitution is made, for instance, in a revolutionary process of constitution making, then what happens is that the boundaries of the political unity are defined or perhaps redefined in this process. Okay? So to go back to the example I gave earlier, so I said that the German people in Schmitt's reading in the revolution of 1918, 1919 decided for a democratic parliamentary republic that was to preserve a capitalist economic system. But there were people, of course, in Germany at the time who were opposed to this constituent choice. So there were communists or radical socialists who wanted to create a socialist society that would overcome a capitalist economy. But these people were a minority. They didn't have enough support, though they had some significant support, to prevail in the revolutionary situation. So they were pushed aside, at times with pretty gruesome violence. Okay? But what Schmitt would say is that, well, I mean, these people, in putting themselves against the decision taken by the constituent power, or the majority of the people, make themselves enemies of the nation. So there's nothing wrong with suppressing them with violence, because they have become enemies of the German people in not deciding the choice for a particular constituent solution that's preferred by most of the people. And in that sense, an exercise of constituent power also defines who belongs to the nation or to the people, namely all those people who for now support the positive constitution that results from the act of constitution making. So there's a sense in which the constituent decision is always unanimous, okay? But that's only because those who oppose it, but who lose out, who are brushed away, are treated as being outside of the political unit. Okay? So Schmitt has the idea that the constituent decision, this type of decision, is the most democratic decision that's ever taken. Okay? Because it's a decision in which the members of the people agree with each other what is to be done, right? But the flip side of this coin is that the dissenters are put in the position of internal enemies. Now, here's a further implication of this general picture of constitutional order or constitutional structure, and that is the distinction for Schmitt, very, very important distinction between constituent power and the constituted power. Okay? So we've seen that the constituent power, the people decide on a certain form of political order, which is then implemented or specified in a legal constitution, a written document with different provisions and so on and so forth. And of course, what this legal constitution will do is to create a number of powers that are exercised under rules contained in this legal constitution. So for instance, the Weimar Republic, of course, the constitution of the Weimar Republic created a process of legislation that put legislative power into the hands of the parliament, elected according to proportional representation. Parliament and the legislative power of parliament, therefore, is a constituted power. Okay? It's not directly the power of the people, it's a power that's given by the constitution that has been the legal constitution that has been created pursuant to the positive constitution that the people have made. And well, the president, of course, or say judges in a Supreme Court, these are also all constituted powers because they operate under constitutional rules contained in the legal constitution. Good. And now, so one claim that Schmitt draws from this is the claim that constituted powers are bound to the choices of the constituent powers. So they are, in all instances, called upon or obligated to respect the positive constitution. So the idea is that the positive constitution, as we've seen, is committed to certain principles of political order. And the claim that Schmitt makes is that Parliament, as a constituted power, does not have the authority to make laws that conflict with the positive constitution. Even though the text of the Constitution does not contain explicitly such a limitation. And this is because decisions, as we've seen, taken by the constituent power are more authentically democratic than decisions taken by constituted power. So this brings me then to the close of this part of the presentation, in which I argued that the general model, this tripartite model of legal order that we see in the three types of juristic thought, is exemplified as well in Schmitt's understanding of constitutional order. So the conception of the legitimacy of constitutional law is akin to the conception of the legitimacy of law in general. Right? Constitutional law is legitimate only if the legal constitution adequately expresses the fundamental political decisions embedded and included in the positive constitution. Just as a statutory norm is legitimate or determinate or applicable only if suitable conditions of normality and homogeneity obtain that are expressed by the statutory norm. What's come into play here is that we need a sovereign decision, of course, that can safeguard the expressive relationship between constitutional law and the positive constitution. And this safeguarding, of course, should fall into the hands of the constituent power. But of course, that isn't quite accurate. That isn't quite the case, because the constitution has been made. So a constitutional guardianship is a political authority that tries to preserve the social conditions, the conditions of homogeneity and normality that are adequate to the working of the constitution that the people have chosen in their last exercise of constituent power. So that is how Schmitt thinks of the role of constitutional guardianship. Good. Now, what does this tell us about who should be the guardian of the Constitution? And that's the last part of this discussion or presentation. And so one suggestion that one might make is that, well, here there's an opening to introduce a Supreme Court or a constitutional court as a guardian of the Constitution. And so indeed, there's a famous American constitutional theorist, Bruce Ackerman, who has a view that thinks that there's a distinction between something like a Schmittian positive constitution and a legal constitution, and who takes it that judges on a constitutional court, the US Supreme Court in this instance, can operate as guardians of the higher, the more fundamental constitution that the people have put in place in an act of constituent power, in an act of political mobilization that went beyond normal, ordinary politics. So constitutional courts might protect the positive constitution against decisions taken by constituted powers that might seem to violate. And this could be a very interesting argument for constitutional review, because it seems to mitigate the charge, or eliminate the charge perhaps, that constitutional review is an undemocratic practice in which unelected judges frustrate the will of the people, or the will of the majority of the people, or of their representatives, as it has come to be expressed in the legislative process. Because what the judges do is to defend the higher will of the people as constituent power against the decisions, the grubby and partial and bargaining style decisions that are taken in a constituted parliament. So shouldn't Schmitt have been sympathetic to the idea of judicial guardianship? Now the answer is no. And I think a moment's reflection makes it clear why this must be so. So we've said that, or you've seen that Schmitt claims that the applicability of legal norms is dependent on the situation of homogeneity and normality. Now, suppose there are constitutional disputes that would require to be resolved by a constitutional tribunal. Okay? Such disputes would arise only if there is absence of agreement on how constitutional norms are to be understood and how they are to be applied. So all interesting cases that end up in a constitutional court are contested cases where good legal arguments can be made seemingly for either side. Okay? Now, if there is such disagreement, of course, as to how a constitutional provision is to be interpreted, as to how a case that arises under this provision is to be decided, then of course we have reached the boundary of judicial or legitimate judicial activity, according to Schmitt. So the disagreement is indicative of the fact that there is no condition of normality or homogeneity in place that would allow a judicial decision to be predictable and determinate. And in those circumstances, Schmitt thinks judicial activity cannot take place. So if you agree with this, then, well, constitutional disputes cannot be decided through constitutional adjudication. So if there is an absence of normality or homogeneity, then, of course, the true task of constitutional guardianship must be to restore these conditions of normality or homogeneity, to take effective measures to restore them. But that is not something that a court can do. It's the executive endowed with the executive power of the state that can do that. Right? Now, we said earlier in Schmitt's general conception of legal order, he thinks that there must be a sovereign who can suspend legality in order to restore a situation of normality and homogeneity. And really, constitutional guardianship is a minor form of this power. So we've seen in the first lecture that Schmitt thinks the president of the Weimar Republic under Article 48 can disregard or suspend all constitutional norms using one of the articles in the Constitution, Article 48. So that is true constitutional guardianship, to put the law aside, to recreate the social conditions under which constitutional norms can have determinate validity. So that is what constitutional guardianship is, and therefore, of course, constitutional guardianship must be assigned to the president as the head of the executive. Oops. Yeah, so doesn't matter. So we are at the end pretty much. So I've talked about the last slide already, I think. So it explained why Schmitt thinks that really it must be a political institution and a politically legitimate institution like the president, who is also popularly elected, of course, who undertakes the task of constitutional guardianship. Yes, there it is. Good. So I hope that this has given you a sense of why Schmitt opts for executive or presidential guardianship. And in the next lecture, we're going to switch over to Kelsen and look at Kelsen's conception of democracy, and we'll contrast it with Schmitt's and see why, from the point of view of Kelsen's conception of democracy, guardianship must be attributed to courts. And then we are ready, once we have that background, in the fourth lecture to delve into the narrow debate between Schmitt and Kelsen on who the guardian of the Constitution should be. So thank you very much for your patience and interest, and I hope you'll have some questions as well.
João, está aí?
Estou aqui. It was a great pleasure, Professor Vinx, to listen to your wonderful talk, thrilling moment at the University of São Paulo. And I'll be brief because I'm sure many people want to ask questions, and I would like to hear more from you. So I will spend my time asking you two very brief questions. Maybe you can, first of all, I would just like to start saying how impressive your explanation of Schmitt's thought was. I think mostly in Brazil, there's a tendency to speak of him more in a caricature sense, and you showed how nuanced and emphasized how complex his thought can be, how his many different ideas can still be helpful today. And first of all, I would like to ask, what do you think about the influence of Kantorowicz over Schmitt? Because it's not very well known in Brazil, I think, but German authors frequently explain how Kantorowicz influenced not only Schmitt but also Kelsen, and it's very interesting. I mean, how the two of them got to very different results, but in a certain way, both of them were really influenced by his thought. They just gave different solutions to a problem he very correctly identified. And you also mentioned about eternal clauses. I mean, the idea of Ewigkeitsklausel, the idea that some constitutions cannot be amended, at least in some of their places. And perhaps you could speak a little bit more about Schmitt's idea of it, because it became popular after the Second Great War, of course, and many constitutions do have eternal clauses. It's a great theme when it comes to constitutional law. Brazil does have eternal clause, and it includes many parts of our constitution. And lastly, I think it was a very fair and accurate exposition of his thought. I did like when you mentioned Corinthians fans, because Lucas is cheers for Santos. So I'm glad you said Corinthians and not Santos. And, and lastly, I want to know, what do you think about his two conditions? I mean, do you think if the conditions are met, that suffices when it comes to the rule of law? Let's just suppose that homogeneity and normality are present. Do you think that answer is the Schmidt's answer is okay? Does it satisfy the rule of law? Does it give enough foreseeability, security, and stability, certainty when it comes to the application of the law, even if both of them are present? I still think there's a lot of many penumbras and dark places over there, even if the two conditions are met. But thank you so much. It's a great honor to have you here, and I'm really sorry I couldn't be there in person, but I'm glad I'm in your hometown. It's a great place to be. Anyway.
Yes. So thank you very much for these questions. And so as to the first, so yes, I think Schmitt was influenced by Kantorowicz, and he does cite him in Statute and Judgment, and relies on his work quite extensively. And some of the reviewers of Statute and Judgment in 1912, or in the years after it was published, they sort of said that Schmitt was a member of this Freirechtslehre, or a proponent of the legal realism of this school. But I think if you read carefully, that's not really what Schmitt wants to do. So he's convinced by the critique of statutory positivism that you find in Kantorowicz, but I think he is uncomfortable with the legal realist idea that once judges realize that they are not subject to the will of the legislator, they should take themselves to be free to arrive at decisions that they think are socially progressive or morally justifiable. So I think Kantorowicz is interested in liberating judges from the false consciousness of subjection to statutory law, so that they can take decisions that are morally defensible. And so Schmitt is against that practical intention, I think. And that's why he wants to argue that you can reconstitute formalism on the level of legal practice, which allows you to sort of hold on to the critical part of the Freirechtslehre, but to reject the political intentions that the members of the Freirechtslehre Bewegung tried to pursue. And this, I think, I'm going to answer the third question next, because I think it's connected to this first. So, of course, I agree with you. I think that's really all I can say, that I don't think that Schmitt's claim that a formalist conception of adjudication can be defended by appeal to standards implicit in practice, that it will work. So the conception of adjudication is so extremely narrow that I don't think it can be descriptively accurate. So we don't have to look, I guess, at political or constitutional cases, or even in run-of-the-mill criminal or civil cases. I mean, you will have a fair number of situations in which legal disagreement appears and must be arbitrated in courts. I mean, that is why people go to court and bring suits. So clearly, Schmitt's account of the legitimate scope of adjudication is much too narrow, and I don't think that there's a way to ever make the judiciary so homogeneous that the judges could never disagree about how a case ought to be decided. So in that sense, I think the conception is not descriptively plausible, and I agree with you on that. To the second question, so Schmitt himself, he claimed after the war that he had been the inventor of eternity clauses and tried to take credit for eternity clauses in the Grundgesetz, but also, I suppose, in other constitutions that in the post-war era introduced eternity clauses. But I think it should be noted that what Schmitt argued in the Weimar Republic was sort of subtly different. So the Weimar Republic, of course, the constitution of the Weimar Republic did not have an eternity clause. So there was an amendment rule that simply determined that the constitution can be changed with a 2/3 majority of members of parliament. And so what Schmitt argued in the Weimar context is that even though the constitution doesn't contain explicit limitations to amendment in an eternity clause, there are still limitations to amendment, which are implicit in the positive constitution or the constituent choice of the people. And that argument, I guess, was not generally accepted in the Weimar Republic. And there was a debate about whether such implicit limitations to amendment can be postulated, but the majority opinion among legal scholars was in rejection of that view. But at least the topic was on the table, and I suppose when the Grundgesetz was made, perhaps people remembered that debate and then positivized Schmitt's view by putting explicit eternity clauses into the Constitution. So perhaps he may have inspired that solution, but certainly the solution, the post-war solution where eternity clauses are made explicit in the written Constitution, has one key advantage over what Schmitt was arguing for in the Weimar context, namely that these limitations are spelled out explicitly in the document, and therefore can provide a foundation for judicial application of eternity clauses and constitutional adjudication. So in Schmitt's Weimar scenario, I mean, he says that the Weimar Constitution is committed to certain fundamental principles, but that's just what he says. And he changes his mind about what these constitutional principles are in the course of the Weimar Republic. And when he talks about how they are to be enforced, he says, well, it's for the president to decide about that, right? And that is clearly, I think, an argument for unamendability that opens the door to extreme political arbitrariness on the part of the executive agent who holds constitutional guardianship. So I think the post-war solution is much more, is much better, much more likely to be legitimate or defensible than what Schmitt had in mind in the Weimar context.
But this would be the same equivalent to what he calls institutional guarantees. We could take a parallel between institutional guarantees and eternity clauses in the post-war discourse.
Yes, but I mean, I think the same question arises about the institutional guarantees insofar as Schmitt wanted to find them in the Weimar Constitution, right? So there was no legitimate way, I suppose, to decide about what limitations to amendment there were or what institutional guarantees there were. There was just scholarly opinion and perhaps executive power, and that's a difficult combination.
Mm-hmm.
Yeah.
But could we read the idea?
Thank you so much.
Thank you.
Desculpa, João. But could we read the idea of these limitations to constitutional amendment in the Weimar Republic, explained by Schmitt, not so much as an eternity clause in the sense that was brought after the war, but more like in a fashion like Dawes' idea of the social conditions that make that constitutional regime possible, more like in a sociological manner, so to speak.
Yes. So I guess you could read them in that way, but I wonder whether that would be plausible for all the fundamental principles that in the constitutional theory Schmitt attributes to the Weimar Constitution. So to give an example, so in the Verfassungslehre, in the constitutional theory, which was published in 1928, he says that federalism is one of the fundamental principles of the Weimar Constitution. Though in 1932, he seems to have had other thoughts. But I mean, I don't see why, say, if federalism had been abolished, why that should have led to an inability to apply other constitutional or legal norms, or say the introduction of an economic regime more weighted towards a socialist economy. I don't see how the laws that might have been made in that vein would have been inapplicable simply because they stood in contrast with what Schmitt took to be the positive constitution of the Weimar Republic. So,
Okay, thank you.
Nicolas.
Professor Vinx, thank you very much for your lecture today. I would like to make two short questions. That is, the idea of the political community is compatible with idea of tolerance, or how could you explain this? And the second question is about the idea of the political community. If this idea have any roots in the debates of the 19th century about the idea of the Geist and the philosophy of history, if have any relation, if Schmitt have any background on these debates.
Right. So, well, I think the conception of political unity is it puts limitations on tolerance. Okay, so I suppose Schmitt's idea is that if someone holds political views that put them outside of the system of principles that the constituent power has chosen as the positive constitution, then the views of that person should not be tolerated or be treated as equal to the views of those who are within the framework of the positive constitution. Because I suppose an attempt to say, try to change the positive constitution in the constituted political process, of course, would be an alienation of the legal, or would lead to an alienation of the legal constitution from the positive constitution, which is to be prevented. And so I think that he would have been quite amenable to perhaps a fair degree of intolerance in order to preserve the coherence, the consistency of the political unity. And so one of the examples that he gives himself in his writings often is the way in which early modern states were religiously homogenized. So where, I guess in the 17th, 18th century, religion was so salient as a ground of political identity that people found it very difficult to live together peacefully as Protestants and Catholics. And the response that many German states had to this condition was, in a sense, to expel people who were not followers of the official religion, and those had to move to another state where their religion was the official religion. And I think these expulsions, Schmitt thinks, were good because they enhanced the coherence and the stability and the integrity of the political unity, and he thinks of them as accomplishments of statecraft. So another example he gives, which is more recent, is in 1923, I think Turkey and Greece, who had been at war with each other just a few years before, they entered into a treaty to exchange populations. So all people of Greek ethnicity in Turkey were sent to Greece, and all people of Turkish ethnicity in Greece were sent to Turkey. And Schmitt mentions this in a footnote in the constitutional theory and says, oh yeah, so this is in line with a proper understanding of democracy, which cannot live with an ethnic division within the political unity. So no, so the conception is not terribly tolerant. So about the Geist or spirit, so I suppose if you think that there's something like the spirit of a nation or the spirit of the German people in a Hegelian sense, perhaps, right? And I suppose what you're claiming is that the spirit is something which has grown organically through history and which has a certain kind of binding force on the people who are members of that nation. So we, as members of the German nation in the present, for instance, we aren't in a position to just decide what the identity of the German nation is, because that has been formed in history in such a way that there's a transgenerational spirit of the people. And then I'm not sure Schmitt would adopt or did adopt a view like that, because in his constitutional theory, he puts quite heavy emphasis on the idea that the people can redefine their own political identity in successive exercises of constituent power. And at least in constitutional theory, he emphasizes the idea that there are no limitations under which the people are in offering such redefinitions. And so I think if you're a Hegelian, perhaps, then you're not voluntarist enough for this conception of constituent.
During our dictatorship, we had a sticker that people put in the car: Brazil, love it or get out. It's like this very strict demand for homogeneity.
Yes.
Anyone else?
But
A reply.
but I guess that is very interesting, because at the same time he adopts a conception of democracy, but at the same time that conception does not have any kind of value of tolerance. So it's a little bit tricky.
Yes, I think for him, so we'll talk about this a little bit more in the coming lecture. So I don't think that tolerance has much to do with democracy for Schmitt. So democracy is the unity of a group that is politically united and that is unanimous in affirming a particular form of life as its own. Yeah. So that is what democracy consists in. And what we think of as democracy, so elections, democratic lawmaking, campaigning, free political speech, advocacy of different political viewpoints. So those are all, things that are okay as long as they don't lead to deep disagreements. But Schmitt doesn't think of these institutional contexts as the places where democracy is truly at home.
Thank you, Professor. First of all, I think you should have said about São Paulo. Great time working. But
Sorry.
My question is about the legal theory in itself. I understand that it's like a conception and something ideal that all judges must think like equally.
Yeah.
But and I know like Kelsen has the pure theory, so it's something like ideal, something like to achieve. But does he say anything to like cases where they can't think the same, or something like tricky, or like how can a decision be made if they can't think like each other?
Yeah, so I think that the view that I attribute to Schmitt is that in that scenario that you described, there is no law. Okay? And therefore, judges can't really take a decision on the basis of law. So all they could try to do is to legislate, to become politicians. But that is something that they're not allowed to do.
So like when there's no way of thinking equally, they kind of need to become the legislator to create something to that case.
But they should not do that.
That's what they would have to do to decide the case. But at the same time, Schmitt thinks that they're not supposed to act in that role because they're not legislators. But of course, it goes back to the question that we discussed earlier, that this idea of adjudication, it's implausibly narrow, right? Yeah. So no one thinks that, no one really thinks, I guess, that courts can never take a legal decision in cases where there's disagreement among competent lawyers about how a case should be decided. So if that was really the case, then that's very little that courts could actually do. And perhaps that's a reason to think that not only did Schmitt have a problematic approach to legal theory, but also that, in a sense, the constitutional ideas that are built on this foundation are to be criticized because the foundation is brittle and unsound.
Anyone else? No. Rodrigo, then Carlos.
Since I had actually two questions, but I'll start with the second. That is, if you can read like Study and Judgment as not so much as a theory of education, but as an attempt to describe what Schmitt later called the bourgeois Rechtsstaat, the bourgeois rule of law.
Yeah, I'm not sure. So I think the later descriptions of the bourgeois Rechtsstaat often emphasize very strongly that the bourgeois conception of the Rechtsstaat is a normativist idea of how a legal system ought to work. Or he claims that in the three types of juristic judgment that positivism is a theory that puts forward an ideal of the Rechtsstaat that combines decisionism with normativism. So it seems that in those depictions of the bourgeois rule of law, this idea of concrete order that he introduces in Statute and Judgment, I think, is separated from the idea of Rechtsstaat. And so that's a reason perhaps to say that he isn't talking about what he later calls the bourgeois Rechtsstaat in Statute and Judgment. There's also an interesting debate in the early Nazi years about whether, among legal theorists sympathetic to Nazism, and Schmitt was one of them, of course, there's this big debate about the Rechtsstaat and whether National Socialist law should continue to commit to the idea of the Rechtsstaat or abandon it. And of course, what all the participants realize in this debate is that, well, if there is such a thing as a National Socialist Rechtsstaat, then it must be very, very different from the bourgeois Rechtsstaat that existed before the Nazis took power. And I think that's where these people want to bring the idea of concrete order back into the picture, and to say that the true Rechtsstaat is a state in which legal norms are interpreted in line with the concrete order of National Socialist German society. But I think in this debate, Schmitt is sort of someone who is skeptical about continuing to use the word Rechtsstaat. And again, that might suggest that really he does not consider the bourgeois conception of the Rechtsstaat the same as the view that he presents in Statute and Judgment.
Thank you. And I had another question, but I think I'll leave it to the Kelsen lecture.
Okay, good, yeah.
Carlos, por favor.
Okay, here I am. Okay, I would like to ask Professor Vinx, thank you for your conference to begin with. I would like to ask you about one of the early texts by Carl Schmitt that are reunited in the book that you published recently with the translation and so on. And I would like to ask you about the importance of the individual, because this is the subject of one of the two great tracts that you collected. And I think that this is an important matter to give us an idea of the worldview that is behind Schmitt's writing about law. So what is the importance that he attaches to the individual in his legal thought?
So I must confess that I find this text that you mentioned, Der Wert des Staates, the value of the state, and the significance of the individual. So I find this a difficult text, difficult to understand. And I think I don't understand it as well as I understand Statute and Judgment. And so one thing that I find interesting about this text is that Schmitt does appear to be quite close to a natural law theory in this text. I mean, closer than in any other of his writings, I think. So he seems to believe that there is an idea of Recht in German, which is prior to the state, and the state's task is just to make that idea of Recht specific and to apply it in a society, in something like the way that Thomist natural law theorists think that the task of a legislator is to determine the fundamental principles of natural law. But he's very, very cagey about the content of this idea of Recht. So he doesn't really present, in contrast to Thomist natural law theorists, much of an account of what the content of this idea of right or of natural law might be. And that also makes it difficult then to say exactly what the role of the individual is. I mean, in a Thomist conception, the fundamental principles of natural law have a bearing on how we see the dignity of the individual and so on. But because Schmitt says so little about the content of the natural idea of right, it's hard to see whether he wants to draw conclusions like that. What he says directly about the individual as far as I understand, is that as an individual person, if you are asking yourself, where does my life draw significance and meaning from, then it draws significance and meaning from the service to the state, where the state in turn is in service of natural law. And so he seems to think that people should devote themselves to service to the state, because in so doing, they will participate in the state service to the idea of law, which is the only thing that's truly valuable. And of course, I suppose you can see here that the beginnings of a hostility against a liberal conception of the value of the individual that sees individuals as making claims against the state. And so there are some passages in Der Wert des Staates where he talks in very condescending and scornful terms about people who are in politics just because they want to have a chicken in their soup or something like that. And that is not what politics is about. And so perhaps the implicit anti-individualism that you see in the later conception of politics is prefigured there in some way.
Mais alguém?
I would just make a comment. So his concept of a normative order has some resemblance with Fuller's concept of implicit law, as in that discussion, forbidden vehicles in the park. But of course, Fuller demands has a less demanding sense of order, of cultural and concrete order. But just also to mention Schauer, it's interesting as this text, Statute and Judgment, poses some questions about institutional design and legal culture. That, for instance, in the conception of presumptive formalism, Schauer shows that in some places of a legal system, depending on legal culture, on legal formation, and on institutional design, like appeals, and if the decision is a collegiate decision, you will have a bias toward a more formalist line of thought, or towards a more realist and finalistic and teleological line of thought. So it seems like this is an important text for this contemporary discussions about institutional design and legal culture, how these variables shape also legal interpretation and not only language itself.
Yes, thank you very much. So that's a very, very interesting suggestion. And so it hadn't occurred to me, but I think you're right to say that perhaps some of the observations that Schmitt makes go in the same direction. So I suppose then the question is whether for Schmitt the formalism is no longer presumptive, right? So his position is overdrawn, or it's too radical in its defense of formalism, and perhaps that's what makes the modern version of the theme more compelling.
Yes.
I have a question.
Rafael.
Professor, thank you very much. I guess my question would be, what are the limits to the possibility of the friend-enemy distinction inside of a political unity? And how do these limits relate to the standing of this political unit on an international level? I know that Schmitt wrote later on about international order and so on. So I guess I'm trying to understand how does this legitimization of the national order correlates to the international one?
Yes. So I think let me try to get to the international order by first talking about how the political can be enforced. So I think one aspect of Schmitt's conception of the political is that so when he says that you are identifying politically with a group when your own life is under the disposition of the group. So he doesn't think that people sacrifice their lives as the soldiers did in the First World War because they're coerced to do so. So his view is that this is a voluntary choice. And in a sense, the claim is that the political community only exists if So it can't be created by coercion. It can only be created if people are willing to make the sacrifice for their nation or their state. And so in a sense, it can't be enforced. So if people refuse to bring up or to show that degree of identification with their community, then the political unity will dissolve. And I guess there's a kind of fear in Schmitt, in some of his writings, in the concept of the political, for example, that perhaps people might just become liberals in the sense of caring only about their private life and withdrawing from politics. And if that's the case, then the political unity that he talks about is just going to disappear. So the legal system will then become an empty shell in a sense that no longer has political substance. And I think he would say this could happen, right? And perhaps it has happened in the international sphere that becomes visible. So I think in the international context, if you look at it from an international perspective, a political unity exists for Schmitt if the members of this group still have the capability to take a decision and to take that decision autonomously on whether to go to war against some other state in order to defend their interests. So the state that has that capability is a political unity. The state that doesn't have that capability isn't a political unity. So ask yourself, does Belgium have the capability to go to war to defend its political interests? Well, perhaps not. I mean, politically speaking, that isn't really feasible. So if they can exercise military power at all, then perhaps in the context of an organization like NATO, where the decisions will be given by other powers like the US. Okay? And so if a polity is in that kind of situation, or a state, I should say, then it's no longer a political unity for Schmitt. And so, yes, and of course the conclusion you might draw from this is that there are very few true political unities left, right? There's the US, there's China, there's India, perhaps Russia, Iran. But then it already becomes difficult to decide whether any other country truly is sovereign in that sense.
But then this is interesting because we only have a political unity at the national level. At the international level, we have a political plurality, not a unit which would give the foundation for international law. Yeah. Anyone else? So, thank you all. And tomorrow at 9 a.m. we are here to discuss Kelsen. Thank you.